He did have a violation, Judge, but he made a poor choice on when he was on GPS house arrest, Judge. He just had a panic attack and cut off his GPS, Judge. He's been in jail.
You said he cut off his GPS?
Yes, Your Honor.
Like with scissors? According to the plea bargain agreement, punishment is to be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon.
What we're here asking for this morning, Judge, is probation.
Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends.
I cannot imagine the fear that person had that was working in that store. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him. You don't have, unfortunately, a good likelihood of being successful if I were to put you on probation.
You're pretty much a lifelong thief, aren't you?
Yeah.
Why?
Well, I had a hard life growing up, and it be difficult for me to get a job. Then I have a drinking problem, me being on psych meds, and it's just like the only thing I know how to do.
But anytime someone goes into a home, doesn't live there, cause commotion because there's a photo that he sent or somebody sent with him dancing with someone else. I don't understand why people let that bother them.
Your Honor,
Yes,
that was not the case.
I mean, that's what it says in the police report, and this is what's been stipulated to. Court is calling 2021 CR 11156, State of Texas versus Albert Alvarez Jr. We're gonna have parties announced for the record for the state,
Joe Hooker for the state.
for the defense.
Linda Corley for Mr. Alvarez.
All right, and are you Mr. Alvarez?
Yes, ma'am.
All right, the defense has filed a motion asking that a bond be set. State, have you had a chance to review that?
I've not had a chance to review the motion itself, Judge, but I know that the court has revoked Mr. Alvarez without bond, and the state is asking that remain in place.
All right, defense, or I'm sorry, state, are you ready to proceed with evidence?
With evidence, Judge, I believe that this is the defense's motion to decrease bond.
They're asking for a bond to be set. He's currently remanded without
Okay,
bond.
yes, Judge.
If y'all
Yeah,
need a moment
Judge,
to.
could I
confirm,
have
that's
a
fine.
moment, Judge?
Sure.
We'll get you a police report or something so you can see what we're looking at, Judge.
Okay, just give us a moment, we'll take that out.
Would you like us to have a seat, Judge?
Yes, please. Thank you.
There's no agreement, Judge.
All right, so we're on the record in 2021 CR 11156, State of Texas versus Albert Alvarez Jr. Our defense has filed a motion to set bond. State, have you had a chance to review the motion?
Yes, Judge.
State, are you ready to proceed?
Yes, Judge.
All right, defense is your motion.
Your Honor, we would like to request that the court set a, we'd like to request the court consider setting a $40,000 bond. His family doesn't have a lot of money. He did have a violation, Judge, but he made a poor choice on when he was on GPS house arrest, Judge. He just had a panic attack and cut off his GPS, Judge.
Wait
He's
a minute,
been
I'm
in
sorry,
jail.
you said he cut off his GPS,
Yes, Your Honor.
like
He-
with scissors?
Judge, I'm not sure. That was just a violation report. I know that state's probably gonna address that with you. He has been in jail for a number of weeks. He understands that was the wrong thing to do. He has suffered in jail, and has assured me that if he has the opportunity to bond out again, he will follow all the requirements, and he will not do that again.
State,
Judge, before I make any argument, I approach with State's Exhibit 1 that has been tendered to defense.
any objection?
No objection.
All right, state's exhibit number 1 is admitted into evidence.
And Judge, that's the prosecution guide from the case that we are here on. And I think it's important that the court is aware of the facts with this aggravated assault.
All right, is there anything else from either side?
Yes, Judge, I would add that the original bond was $80,000 and that included full house arrest GPS. And that fee for that GPS was waived by the court, and still Mr. Alvarez chose to cut off his ankle monitor. And I also think it's important, just for the safety of the community, that the court's aware that Mr. Alvarez was released from TDC custody on March 15th of 2021. And you can see that a day shy of 6 months, Mr. Alvarez is picking up a new offense with a new victim here in Bear County.
All right, and so State, I'm assuming you're asking that he remain without bond.
Well, Judge, I would ask that if not that his bond is at least as high or higher than it was originally, rather than decreasing it from what it was when he then decided to cut off his ankle.
All right, defense.
Judge, nothing further from defense.
All right, Mr. Alvarez, you cut off your GPS. You're charged with an aggravated assault with a deadly weapon. And let me see, any objections to the court reviewing how the case is indicted?
No, Your Honor.
So you're charged with aggravated assault with a deadly weapon and you're indicted as a habitual, which means your minimum is 25. Do you understand?
Yes, Your Honor.
So the court placed you on GPS, and GPS is designed so that the court will know your location. And so that pretrial services will know your location. And you removed that GPS monitor. Does anyone know where the GPS monitor is? Was it ever collected?
Judge, it might have, I believe his mom may have given it to pretrial services. I'm not positive about that. I do know that I believe he was picked up the day afterwards. The very next day, his mom he was staying with his mom, correct? And she takes this very seriously, and she's actually the one that called in and told pretrial services what had happened. So, Judge, I do believe that he would be staying with his mom, and his mom will not hesitate to notify the court again if there's any problem.
All right, the motion is denied. He's remanded without bond. Have you had a chance to confer with the state on this case?
I have, and I'm going to talk to my client further.
All right, thank you.
Thank you, Judge.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am, Your Honor.
Are you satisfied with the way you've been represented?
Very satisfied, ma'am.
Are you a U.S. citizen?
Yes, ma'am, Your Honor, I am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. There's to be restitution of any to Eduardo Murillo, Murrillo. Did you understand that to be the plea bargain agreement?
Yes, ma'am, Your Honor.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions?
No, there have not.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Statement on first state's exhibit number 1.
No objections.
Mr. Alvarez, I'm sure you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just request that you follow the plea bargain.
All right, and there's no issue with sanity or competency.
Judge, I've had many conversations with Mr. Alvarez in reference to all of those issues, and I am comfortable moving forward at this time.
All right, the court will follow your agreement, sentence you to 20 years in prison. There's an affirmative finding of a deadly weapon. Give you credit for any time served. There's to be restitution and no contact with Eduardo Murillo. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing further, Judge.
All right, Mr. Alvarez, I'm sure you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, Your Honor. I do.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am, I do.
All right, good luck to you, Mr. Alvarez. Mr. Alvarez, you're gonna have to do better. You understand?
I do understand, Your Honor.
All right, and you have neck tattoos as well, I see. We can go on the record.
What's that?
I said you have neck tattoos as well as, I see.
Yes, ma'am, I do.
Were they painful?
Yes, ma'am, but I don't plan to get any more.
Okay, you never think about stopping. You're just like, let's finish it.
Yeah, it's done.
All right, have a good rest of your day.
Good morning. Are you Caden
Yes.
Fontanet? Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
I think that's enough.
Okay.
Mr. Rojas, you may make argument first.
Thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontainet's defense, he is a young offender. I know the court is tired of hearing the same story over and over again, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, he's trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that, we've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road to prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Plan on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly, if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all of that stuff's fine, but you, Judge, are where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman.
The prosecutor really surprised me here with the conviction behind what he was saying, and he is 100% right too. I don't know if you guys have noticed it like I have around the country, but I just see it all over the news where these younger guys are just becoming menaces to society with no care for anybody else but themselves. Like, it's gotta be every day. And like, even though a charge like robbery usually only gets a few years in prison or even probation most of the time for first-time offenders, this honestly just feels like a completely different type of case. There's just something about this situation that just feels off to me. Like, there's gotta be more going on here than what we're being told in court. But yeah, guys, now we're about to see if the judge is going to give him any kind of mercy at sentencing here, or if she's about to make an example out of him right here. Keep in mind, 25 years is the max here.
So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. State's attorneys were recommending youthful offenders, probation, let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time, pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. Come on, Mom. Here. Going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff.
Ms. Contour,
Thank you, Your Honor. We're here this morning in the state of Ohio versus Shalita McAdams. We were last before you on May 19th of this year. At that time, the defendant did enter a plea to count 1, theft, a felony of the 5th degree. Your Honor ordered a pre-sentence report and a victim impact statement, which have been completed. We are here today for the purposes of sentencing.
Ms. McAdams is requesting community control in this case. She understands that she did wrong here. She took full responsibility in the pre-sentence report. Use of alcohol and depression over the recent death of her father, and she indicates she was running with the wrong people. Gentleman and his girlfriend kind of put her up to going in to this store and doing what she did.
what do you want to tell me, Ms. McAdams, before I sentence you?
I just want to take accountability for my actions, apologize to Arts and Beauty for taking their items, and apologize to the court.
Who's Jesse McDade?
That's Renee's boyfriend.
Who's that?
Renee, the one that took me to the store, her boyfriend.
Renee, who's Renee?
Who's a so-called friend. I thought she was a friend at the time.
You went into the store with Renee?
Yeah. No, I went to the store with our dude.
Who?
Jesse.
Where was Renee?
Renee, she was sitting in the car.
Why did you go into the store?
Because they was on pay me to go in there.
They were going to pay you for what?
To go take the merchandise.
So what did you do? Tell me how this plan was executed.
No, I just went in there and took the merchandise, and then she paid me.
What was Jesse doing?
Oh, he was in the store. He was walking around, putting stuff in his pocket too.
Was he talking to the workers?
I don't recall, no.
So you just went right up to the counter and took a whole bunch of sample perfumes?
Yes, sir.
You took 27 bottles of sample perfumes, right?
Yes, sir.
What'd you do with them?
I gave them to her.
Well, you took a big bag in there to put them in?
Where's my purse?
How big is your purse?
That big. It's just a deep purse.
So did you take all the bottles that were out there?
No.
How many other bottles were out there, you think?
I don't know how many other bottles, sir, but I didn't take all of them.
So you took them out, you left the store, and where'd you go?
No, and I went back home with my nieces and nephews.
Well, you went into the same car you came in, right?
Oh, yeah.
With Jesse driving? Or who was driving?
Renee was driving.
What's Renee's last name?
What's her? I think it's Ramsey.
Huh?
Ramsey.
Ramsey and
Yes.
Jesse McDade?
Yes, sir.
How long had you known them?
Not too long.
Where'd you meet them?
through another friend.
Huh?
This girl named another female.
Who's the other female?
I'm trying to remember her. Taisha Jones.
How'd you know Taisha Jones?
Running the streets, sir.
And she introduced you to Renee and Jesse McDade?
Yes, sir.
Why?
Because I was asking her, how can I make some fast money?
And so then you met Jesse and Renee, and how did they tell you were going to make some fast money?
They told me what to do to go in the store, and they bought me some drinks, and I went in there.
So did you get back in the car?
Yes, sir.
Where did you guys go?
After we left the store, they dropped me off.
Where?
To my sister's house.
How much they pay you?
Well, it was $150.
They gave you $150 for going there and stealing $4,400 worth of stuff?
Yeah.
Oh, they ripped you off, didn't they?
Yes, sir.
Now you're the only one that got caught, right?
Yes.
Jesse's still out there running around stealing perfume bottles. What does he do with them?
I guess he's selling them. I don't know. I don't keep up with him like that.
What?
I don't keep up with him, sir.
Were you with him on the day before also?
No.
Who were you with the day before?
You talking about the girl? I don't know.
You don't know?
I know I wasn't with them.
Huh?
I was not with them, sir.
Well, you were in North Homestead in an Ulta store there the day before, right? Stealing perfume bottles?
I don't think that was the day before.
That was the day before.
Oh, it was?
Who were you with?
Oh, well, then I was with them then. I didn't know that was the day before, though.
How much did they pay you for that one?
I forgot.
How much did you steal there?
I don't remember, sir.
You're pretty much a lifelong thief, aren't you?
Yeah.
Why?
Well, I had a hard life growing up, and it be difficult for me to get a job. Then I have a drinking problem, me being on the psych meds, and it's just like the only thing I know how to do.
Why don't you learn how to do something different? You got a robbery in 2011 you went to prison for. You got drug and alcohol cases all over the place. The theft in North Olmsted is still pending. You got 9 warrants out there. What are those all for?
But public intoxication, open containers.
Theft. There's one for theft in
the County.
Rocky River or Westlake. There's one in Geauga County for theft. That's after this theft.
So I got 2 other thefts or 3?
You got probably 3, at least. You've been put on probation many times before, right?
Yes.
And you don't comply with probation, right?
I did my time for it.
Right, because you don't comply. So they eventually terminate you and send you to prison or jail, right?
Yeah.
Okay. So you're telling me that you only met this Jesse McDade through somebody else you run in the streets with, and you haven't seen or heard from him since, right?
Yes.
Okay. I must confess, I didn't know there was such a big black market for stolen perfume out of Ultas, but apparently there is. Did you know that?
No.
So you know nothing about what happens after you steal that stuff?
No, sir.
Okay. You sure about that?
What you mean by do I know anything what happened after that?
Right, that's what I mean.
I mean, yeah, I know if I get caught, I'm gonna get in trouble and go to jail. I understand that part. I gotta pay the consequences for it.
The consequences don't seem to faze you, though. Because you keep stealing, and you keep getting caught, and you keep getting sentenced, but then you get back out and you keep doing the same thing. So what exactly are you accepting responsibility for?
I'm accepting responsibility for not going back in the stores and learn my lesson.
Okay.
Because it keep on giving me the same results, the same place, and I'm getting tired of keep going through this.
Well, maybe then you'll stop. I don't know. Ms. Contour?
Thank you, Your Honor. The state is recommending prison. The defendant has 5 prior felony convictions that I counted, 2 prior prison terms, and 9 warrants out for her arrest, as well as the 3 pending felony theft cases. So we do not believe she's amenable to community control sanctions.
Okay. Well, I reviewed the pre-sentence report. Did you get a victim impact statement?
No, Your Honor.
Well, we sent one out, didn't we?
Yes, sir.
And they don't bother to. So what, are you asking for restitution?
$4,472.
Where does that number come from?
That is from there was 27 tester bottles that were taken. That is the price added up of all 27 of those bottles.
Where did that price come from?
The store.
Where? I thought they didn't submit a victim impact statement.
They didn't. That was from the police report, Your Honor.
So they said to the reporting officer that night that the Tom Ford Cafe Rose was worth exactly $200.
Yes, Your Honor. And I did talk to them on the phone prior to indictment.
Is that the price of the perfume full sample bottle?
Yes, Your Honor.
Weren't these sample bottles?
They were.
Meaning some were used?
Some were used. Mr. Matthews and I had a conversation about this before it was indicted, and I believe prior to the defendant pleading, that if I have the code section in front of me, but the law does consider in a case like this, when they're stolen, that it should be the price of the full item.
What statute is that?
Give me a second.
And why would they be entitled to? First of all, why don't they bother to make a claim on this stuff if they're concerned about their stuff getting stolen over and over? Because apparently this is an epidemic that I wasn't aware of.
Your Honor, I think it's 2913.61, which is what I have in front of me. I'm looking for the section in which it states that specifically. It is D2 of that section.
How do I know that this bottle of Tom Ford Cafe Rose was worth $200? Says who?
That was reported to the officers at the time that this theft was reported by employees of Ulta.
Okay. Has that been verified at all by any means?
That's what they reported to the officers.
So just what they said it is worth?
Yes.
Okay. All right. I've considered the contents of the pre-sentence report, which, as Ms. Contour has indicated, reveals a lengthy record and multiple prison terms. And I have considered the fact that there is no victim impact statement despite the request to help verify things, amounts, and contents. I considered all the provisions in 29, 29, 11, 12, and 13. Clearly, you're not amenable to community control. You get penalized mostly through probation, and you refuse to comply and change what you're doing. So I'm going to sentence you to 12 months in prison. When you get out, you might be on post-release control, and the costs are assessed. Anything further, Ms. Contour?
Nothing further, Your Honor.
Mr. Matthews?
No, Your Honor. Thank you.
All right.
Court is calling 2022 CR 2352, State of Texas versus Aaliyah Rodriguez. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the
Efrain Torres
defense.
Jr. from Ms. Elia Rodriguez.
And are you Ms. Rodriguez?
Yes, Your Honor.
Showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State's proceeding on the lesser included offense of assault causing bodily injury. And for the record, we are waiving and intervening any familial allegations.
Any objection?
No objections, Your Honor.
Ms. Rodriguez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review this document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
You understand that the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment for that offense is up to 1 year in the Bear County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
yes,
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine? Did you understand?
yes,
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
All right, off the record for a moment. Mr. Nahara?
Yes, Your
I'm gonna
Honor.
send you to breakout room number 1 with your client.
Wonderful. Thank you, Judge.
Mr. De La Rosa, if you go to breakout room number 1, please. We're back on the record. According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault bodily injury. There's a $0 fine and the state recommends deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Yes, Your Honor.
There have been motions that have
Oh,
been
no, I
heard,
think you said, are we abandoning? No, no, Your Honor, that's not.
so there have been no motions?
No.
All right, so you understand if the court were to follow this agreement that I would not grant you the right to appeal?
Yes, Your Honor.
All right, next I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 18 months. There be no harmful or injurious contact with Eric, E-R-I-K, Gonzalez, G-O-N-Z-A-L-E-Z, and hostility and aggression control course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense of assault bodily injury as a class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, Your Honor. At this time, state offers states exhibit number 1 is attachment.
Any objection?
No objection.
Ms. Rodriguez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. How the court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Judge, my client Elia Rodriguez just takes responsibility. She wants to move forward and get this past her. And she would appreciate if the court just follow the recommendation offered by the state.
All right, so Ms. Gonzalez, I'm sorry, Ms. Rodriguez, I'm reading other people's names in the thing. Are you and Mr. Gonzalez still in a relationship?
No, Your Honor.
All right, so there's no need for you to have any contact with him.
Well, to some extent, yes, Judge, they have 4 children.
Can't that be through a third party? Because it appears,
Well, Judge, they are going through a divorce proceeding right now. I don't know how that's gonna play out. I don't know what's gonna be ruled, but as at this time, I believe, are you guys communicating in regards to the kids?
It is through the third party.
so they can continue. I think it's best that they do it through a third party.
Sure, that's fine, Judge.
All right. So,
And Judge, I have to say, we've spoken with the complainant. He specifically asked for this. I understand the court's decision. I just want you to understand our recommendation was based on.
all right, thank you. But anytime someone goes into a home, doesn't live there, cause commotion because there's a photo that he sent or somebody sent with him dancing with someone else. I don't understand why people let that bother them.
Your Honor,
Yes,
that was not the case.
I mean, that's what it says in the police report, and this is what's been stipulated to. So this is what I'm saying. What I'm saying is, if somebody is unfaithful, if somebody's dancing with somebody else and you think they're unfaithful, put yourself on pause and make a decision. Either you're gonna accept that or not accept it. If you're not gonna accept it, just call it time out on the relationship, call it quits. But now what's happening is you have a third deferred adjudication for an assault bodily injury. That could have easily been a deferred adjudication for a burglary of a habitation. You understand?
Yes, sir.
All right, are you employed?
Yes, sir.
What do you do?
I'm a party planner and I do sales online.
What do you sell?
Victoria's Secret.
And where are your children?
School.
All right.
And my daughters are with my mom right now.
Okay, and where were they during this whole incident?
They, I think they were with my parents.
All right. See, if people would have been with their children, either you or him, none of this would have happened. All right, this is what the court is going to do. 18 months deferred adjudication. I'm sorry, deferred adjudication, parenting classes, 80 hours of community service restitution. Once you complete the parenting classes, the court will waive 40 of those community service restitution hours. And if you provide proof of a COVID vaccination, the remaining of those hours will be waived. The court is not requiring anyone to get the COVID vaccination, but if you do, and you provide proof, or if you've had it and you provide proof, the 40 of those hours will be waived. There's going to be regular reporting by Zoom or in person. There's to be no contact with Eric Gonzalez outside of court proceedings. There's to be the hostility and aggression course, aggression control course, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. If you're drug tested today, what will the results be? All right, there's to be regular UAs. And there should be a drug test today, Rebecca. Rebecca, is there anything else she needs?
Were you gonna do field visits, Judge?
Yes, let's do field visits, regular one time per month. Ms. Rodriguez, is there anything else you need from the court in order to be successful?
Judge, since she does party arrangements and she sells online, would an affidavit suffice, or how would you want me to show proof of that?
Oh, I'm sure just, I'm pretty reasonable on that.
Okay.
But she will have to show some type of income that's coming in.
Okay,
All right, she has 4 children to support.
correct.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. And you know, before entering into another relationship, get an orchid. And when I say get an orchid, we're off record, Brenda. What I mean by that is this. When somebody gives you an orchid as a gift, it comes with the beautiful blooms, right? So when you get that orchid, and usually they're like $12.99, and it has the blooms on it. Wait until the blooms fall off, which they will, probably within like 3 months or so. And if you're able to get that orchid to bloom again and keep it alive for 1 year after that, you'll be ready for a relationship. And I say that because orchids require patience. You can't move them around too much. They like to be talked to. You got to put the right amount of fertilizer and everything. Good luck to you.
Judge, do you want her to report with CeeLo Reyes in the back?
Yes.
Thank you, Judge.
Thank you.
Yeah, Coach Sean.